Thank you all for joining us again this month for the Jonge Read webinar. It's always very exciting to come together and come up with some things to talk about. And this month we've got Terry Finn from our Melbourne office joining me. So we'll no doubt have a bit of fun and variety. Now, before we get stuck into that, I'd normally like to give you a little bit of update on what's happening in the insolvency world from our perspective. The reality is there's probably not a lot of change. The last quarter, we have seen a slight increase in the number of insolvencies, but probably not as much as the papers would make out is going on at the moment. But what we have seen, and for those who attended our breakfast seminars, we talked about the ATO being very heavy in the debt collection mode. We are seeing quite a significant increase in the early parts of that activity. So director penalty notices are definitely back on the rise. They had a bit of a hiatus after they did the warning letters last year, but we're also seeing the creditor stat demands being issued at the same time as the director penalty notices. So they're really trying to put the stick in to get people to move, and that leaves you very limited time to deal with stuff when it happens. So something to be very mindful of. I think we often talk about, or we have spoken about it on many of the webinars before, about making sure that the director's addresses are correct on ASIC. But probably more importantly, particularly with the director penalty notices, actually having people keep an eye on their MyGov. Because all of the director penalty notices are being brought up on the MyGov bright and early, often before the letters are received, so you can get a bit of a head start. So maybe in your monthly newsletters, it might be worth getting people to remind them to keep an eye on that if they are people in business. So that's just probably
one thing there. Actually, I've noticed very recently in the last week or two, a lot more of the ATO threatening to report taxpayers to the credit authorities, so it will appear on their credit reports. So really seem to have ramped that up recently.
Yeah, it's interesting one, Terry, because they were really, I think last year we reported that there was only like 25 or 27 reports of it, but they are certainly pushing the barrow to get that going now. Now, whether that actually has a massive impact or not, we'll wait and see, but it's certainly, people's credit reports certainly scare people into action, often more than actually having a personal liability, which is a bit scary.
It is. I think the ATO has even foreshadowed that they intend to report about 20,000 in the next few months to credit reporting authorities.
Yeah, so they're certainly upping the ante now, and I would suspect that that will mean the massive impact on insolvency numbers into the new year. So Terry, thanks for that. So we will jump in. Before we jump into the topic today, for those who don't know you, you've been be about 8 years that I've been putting. I've had you on board.
Yeah, it's only been 3, but it seems like 8. No, it's been just over 8 years, and prior to that, I worked for a number of insolvency practitioners over the previous 30 odd years. And when I was trying to work out how long to say I've been in the business for this webinar, next January will mark my 40th anniversary in insolvency. So way to feel old, Terry.
Well, you've certainly seen some things, and there'll be some interesting stories that we'll get out of that as we go through today, and for anyone who catch ups with you afterwards.
Yeah, let's hope so.
So Terry, when we talked about what we were going to do, we did decide to go a little bit different in the way that we would look at things today. So, and that is that we're actually going to have a chat through some of the scenarios where clients haven't taken our advice. So it's well, sort of, I guess. They come back to us, didn't they? So today we're going to talk through a number of case studies where people didn't take the advice in full or part. And as most people would know, and for those who don't, then I'm going to tell you again anyway, that we always provide a fully documented strategy to our clients on a no obligation basis. So the focus is very much about giving you the opportunity to bring them to us so that we can have a look at what we can do to help, and then we provide a no obligation strategy. And I think you'll see through through these case studies that no obligation is really there. And I think it's important for all of you to know that, so that you can safely bring them to us, knowing that we're not going to pressure them or push them into something that they may or may not be ready for. Whether they need it or not is another thing. And you'll see in these case studies that some of them needed the advice, but they weren't willing to take it. But we let them make their own decision, and then they can come back to it in their own way. So hopefully that will help give you a little bit of confidence on that front. So Terry, why don't we start today with a simple one? I guess I would say it's pretty good general advice that will come out of this one. So let's talk about something that was done where a client who through a personal insolvency.
Okay, thanks, Ashley. Cheating a bit here. It's not actually a Jonge Read client. This was a client from when I worked on the dark side, before I saw the light. I was working for a trustee in bankruptcy, and we had a bankruptcy. It was pretty innocuous, nothing much in it. Ran the 3 years, no problems. A couple of 2 or 3 months after the client was discharged from bankruptcy, I received a call from his bank asking if he was still bankrupt. I said no. Why? And it turned out that a large deposit had been made into his account, and the bank still had the account flagged, and they wanted to know if the trustee had a claim on that.
Well, I'm seeing a tragedy appearing on top of a tragedy here.
Oh yeah, and I'm thinking, well, I don't know what it is, but it's unusual for someone to get a large sum of money that soon after getting out of bankruptcy. So I called the client, and unfortunately, he had received an inheritance from his mother's deceased estate, and that's what the large deposit was. His mother had unfortunately passed away while he was bankrupt. Therefore, the inheritance belongs to the trustee. So there's your double tragedy, Ashley. Not only did his mother pass away, but he lost the inheritance. In effect, she left it all to the trustee in bankruptcy.
So, why would you want to bring this one up to start with as one of your stories?
Well, the client in that instance, obviously, with all he's going through, didn't think to notify anyone of the bankruptcy, but also when he went bankrupt, he did not foresee that his mother was going to pass away in the next 3 years. Because she did, he lost his inheritance. Now, if he had planned properly, as we know now, if he'd planned before the bankruptcy and taken some advice, he could have avoided losing the inheritance by having his mother change her will and leaving the money to a testamentary trust. Now, we don't give specific legal advice. We're not lawyers. I think we all know that by now. We would have recommended, and we do recommend to our clients, if we're recommending bankruptcy, that if they are included in anyone's will, they have it reviewed. We can refer them to a wills and estate lawyer to set it up so that if the unforeseeable happens, not all is lost.
And I think I guess it's one of those things, isn't it? There's a lot of little bits that happen when someone needs to go into personal insolvency. As you said, this one was a fairly innocuous one. He just got rid of some debt. There was no major issues in it, no houses. But, things like even getting people to cancel their lotto cards.
Yes.
Being a registered lotto, having your registered golden lotto ticket or card or whatever it is. If that's registered in your name and you're bankrupt, and then you happen to win the 20 mil that's on tonight, then the trustee gets that. So it's those little things by making sure that they're done early that are really important. So always referring straight can have some unforeseen consequences, I guess.
Yes, and I do get a lot of clients saying, what happens if I win lotto? And I say, you won't, your wife will. But you're right, and it is a standard in our proposals. If we're recommending bankruptcy, we do a standard paragraph saying if you are included in someone's will, please get them to review it and take steps if necessary. Now, a lot of people think, oh yeah, that's just a standard, gloss over it. Dad's still healthy. He's going to live forever. Unfortunately, no, he's not. And we hope.
Well, we hope he is, but
yeah. But we also hope that he's not going to pass away in the next 3 years while they're bankrupt. But life and death can have different plans for us, unfortunately.
Unfortunately, that's true.
Yeah.
So, all right. So let's move on to one of our current past matters, which is a tragic example of why it's so important to get someone working with you through an insolvency. And the first case is really a case of a person picking and choosing from our advice.
That's right. And just by way of a bit of background, this client had a company that wasn't doing very well. He had expired DPNs that I know you've all heard a lot about from previous webinars. We recommended that he have a controlled exit of the company, close the business down, wind it up, and then he go bankrupt. So that's all pretty simple.
Pretty simple. So do tell what happened from there.
The close down went well, not a problem, smooth as. Then we come to his bankruptcy. I think he may have been a bit heartened by how well the liquidation had gone, and he thought, well, I'm not going to pay for a trustee. I'll just let this one go through to the government trustee, AFSA. I won't have to pay for it then. The issue that he had was that our client had a pretty nasty work accident some years prior, about 20 years, I think he will take, and he received compensation for that accident. Now, compensation is exempt property in bankruptcy, and even compensation received prior to bankruptcy is exempt, as are anything purchased with that. So as long as it
right. So Terry, I'll just get you to sort of dig into exempt property a little bit, because it's not something that we've talked a lot about in webinars before.
Right. In the Bankruptcy Act, there's certain property that is available to the trustee to pay, obviously, the trustee's fees and creditors, but there's certain property that is not. Simply put, no necessary household items that you can't take them off someone. There's a car allowance. Superannuation in a complying fund is not available in a bankruptcy. It's exempt property, as is compensation for personal injuries. Now, the compensation is a little bit different from some of the others in that it traces back. So compensation received prior to bankruptcy is still exempt, as are any assets that are purchased with that compensation.
Okay, so you talked about super, and I reckon probably half the people listening would have spiked up about that, but we'll leave that one for a little bit later. But when we talk, one thing with compensation is that we've got to be mindful that in itself is a complex area. So please don't take this as a written rule, because in compensation you can have an income component and you can have a pain and suffering component, and different things can apply in different spots. But anyway, we'll stay focused on here. So unless I'm hearing you wrong, our client actually received the compensation payout well before he went bankrupt.
That's correct.
Yeah.
And he paid a deposit on a home for his family.
Yep.
He set up a company. He loaned a lot of money from his compensation to the company. The company was paying his mortgage and made payments for extensions and renovations, etc. So that was, again, repaying the compensation, could still be traced through.
Right.
In this instance, and as you know, Ashley, we do quite a bit of research when we do our proposals. And if we come across something that might be a bit complicated, we look into it and try and sort it out. And that's what I did in this case. I did quite a bit I learned a lot about compensation and its exemption. I had discussions with lawyers and registered trustees, put in the client scenario, and as a result, I was very confident that we could protect the assets that were purchased with that compensation.
Right. Okay. This is sounding more like a good news story than a bad news story, Terry.
It was a great story, actually. I was pretty proud of the strategy I did and the results of the research. So anyway, then it came time to go bankrupt, and he wouldn't take our advice. Didn't want to spend the money to appoint a trustee. He did transfer his house to his wife prior to going bankrupt for natural love and affection, which is not something I would normally recommend because that doesn't stand up in bankruptcy, but it was an exempt asset anyway. So it was not an asset that was available in bankruptcy. No problem with transferring it. So the client went into bankruptcy, appointed AFSA to manage his bankruptcy. AFSA, they are fairly short-staffed. I think they don't have enough resources to handle all the bankruptcies they're given. So at any opportunity, they will transfer a file out to a private trustee, to a private registered trustee.
Sorry, Terry, just before you go on with that bit, you mentioned about the fact of transfer of love and affection. One thing we want to be really clear on, it's not normally something that we would recommend, but
Correct.
In this case we did because of the compo and the tracing rules that applied through. Anyone who thinks about moving someone for love and affection really needs to think twice about it 99.9% of the time, because it doesn't actually protect anything, does it?
No, it doesn't. And the Bankruptcy Act specifically says that love and affection is not valuable consideration.
Yeah.
So
yeah, sorry. Anyway,
it doesn't stand up in bankruptcy, but this is not an asset that was available in the bankruptcy.
So our client really, by the sound of it, actually took part of the advice that we wrote in our proposal to do things for his house, but did it himself rather than actually focus on using us.
Oh, he used us and he did everything we told him.
Right.
Until it came to actually going bankrupt.
Yeah, okay. All right, sorry, go on.
Yeah, as I said, he appointed AFSA, which was against our advice and against my pleadings, but he was still our client. We were still working with him through it with AFSA.
Yep.
And then AFSA, not unexpectedly, transferred the file to a private trustee, a registered trustee in bankruptcy.
Mm-hmm.
Now, a registered trustee in bankruptcy is running a business. He's trying to make money for himself. And also, as I think we've mentioned plenty of times before, registered insolvency practitioners do have a duty to recover as much as they can for the creditors. So here we have a trustee who's been landed with a file. There's no money to pay him or the creditors.
So, and I think that's important, that is understanding is that AFSA doesn't pay them to take over the files. It's almost like a duty or a requirement for private trustees to take on this public work when they're requested of.
That's right. And AFSA generally does it when there is enough money to pay a trustee, or when it's just too complicated and there might be a chance of a trustee getting some money out of it.
Yeah.
Sometimes they don't get paid. That's part of their business.
Yeah.
So in this one, the registered trustee decided that he would go after the house and the transfer. And he wanted, it was over $500,000 his claim was, against the wife for taking the house away from her husband. Now, he did not accept the compensation tracing argument, and he got very litigious. Now, as confident as we were that the tracing argument would work, when someone gets involved in litigation, no one wins. It'll go on forever, cost a lot of money, cause a lot of stress. But that's the way the trustee decided to go. Our client had to react to it. And to cut a long story short, if it's not too late for me to do that, it ended up costing the client many sleepless nights and more than $150,000 in legal fees and settlement funds to get the trustee off his back and settle the whole thing. Still not a bad outcome when you compare it to over $500,000.
Yeah, that's right. Yeah.
It could have been a lot better if he had followed our advice and spent the $10,000 or $15,000 to appoint his own trustee who would look at it probably more commercially. And I remember when it was all over, and it was very stressful, but this client said, geez, being cheap has really cost me dearly, hasn't it?
I'm sure you didn't say I told you so, Terry.
Well, it's hard to resist sometimes, actually, but that wasn't the time or the place.
No. And I think the interesting thing with that is that it's one of those great things of the whole law institute or the whole law system, isn't it? Is that it comes down to how you want to interpret it, whether you want to fight it or not, or whether you just you take the medicine on some of these things. But law is so interpretive, and the bankruptcy law is no different to anything else.
That's correct, and it's not common that people make these compensation claims. It's quite unusual. So some people don't necessarily understand it fully.
Yeah.
And some people just try it on anyway, because everyone knows if you get into litigation, no matter how good your case is, you can always lose.
There's always an alternate argument to any legal situation, no matter how simple it is. Yeah.
If you're going to fight it through, it'll take potentially a couple of years, a lot of stress, a lot of money. No, you don't get that back.
No, and look, obviously the people listening here today, they're not the ones who are making these decisions to not spend an extra $10,000 or $15,000. But I guess the reason why, or the moral, I guess, to the story is that regardless of all of these things, having your clients have someone on their side can certainly make things a lot easier and a lot better for them. Now, the tracing thing caused a lot of arguments. If that money was cash in the bank, it may not have been quite the argument, but the reality is and we're not bashing insolvency practitioners by any stretch. I mean, again, they're a very critical part of our business model, but they've got their role to do, and our role is to look at the fights on the other side for the director or the individual, more than it is our job to focus on the benefit for the creditors.
That's right. And as you know, our business has sprung up from that very philosophy. Somebody needs to help these people because there are plenty on the other side.
Yes. Yeah. All right, mate. So let's look at another frustrating matter that I know you've had to deal with recently. This one's a liquidation matter, but this time the client didn't engage with us at all. Well, originally anyway.
That's right. And this client, just by way of background, owned a number of service stations. I think it was 3. And as is common with some businesses of that nature, he paid most of his staff under the counter in cash. He came to us. The ATO had begun an audit on him. And I think Fair Work had also done some investigations. And the accountant pretty much knew how the audit was going to end. It was going to be very expensive. So the accountant brought his client to us. We developed a strategy to restructure the service stations, liquidate the old company once the new structure was up and running. There are a number of things we did identify as a pretty involved sort of a process. And one of the things that we did identify was there were large loans that the director could be held liable for. Also, because the company had been trading at a loss, a liquidator was likely to go after the director for insolvent trading. So potentially it was very, very expensive for him. We gave him a proposal, a strategy to deal with it. He thought our strategy was too expensive and he didn't want to engage us. It wasn't expensive when you compare it to the sort of DPNs and liquidator claims he was potentially facing, but he didn't want to spend that money. I guess you could say he took our free, no obligation advice, but just didn't want to put his hand in his pocket to engage us. And again, I think sometimes our advice is probably too detailed and too simple. He thought he could do it himself.
Yeah. And look, I know it's a bit tongue in cheek, but at the end of the day, Hank and I are still very proud of the fact that we provide the no obligation advice. because people really, they are in a distressed state, so they need to be given that advice without fear or foul that they would need to pay fees and get nothing more from it. And allowing us to deal with that sort of thing. Now, Terry, just quickly, there was a question that came up on the last one, folk, going back to the inheritance one, and that is, what is more important, the date of death or the date of the payment?
Date of death. That's, I believe that's when the person, that the beneficiary of the estate becomes entitled. Now, technically, I suppose, an administrator or an executor can't make a distribution until they've got their probate, but the entitlement vests, I suppose, with the beneficiaries at the date of death.
And I think in your example, that's really clear that the date of death was before bankruptcy ended, but the payment didn't come till afterwards.
That's right.
And that's where you get caught. So very good question, because it is a really tricky one.
Yeah, and just on that, I haven't come across any cases where that's happened again, but I have seen a few where the executors have been prudent enough to do bankruptcy searches on the beneficiaries before they make a distribution.
Right.
And that's potentially an executor or administrator of a deceased estate could be held personally liable if they've made the distribution and a trustee in bankruptcy puts his hands up.
Right.
Says, okay. Hey, you should have paid me.
All right, so we'll jump back to the service stations now, but in our case, the client decided not to become a client to start with, and then he went about his thing. Obviously, there's more to the story. Otherwise, we wouldn't know about it if he just went off on his way. So I'll let you continue on.
Thanks, Ashley. And while we were talking about the deceased estate there, approximately 2 years has passed, and the client and his accountant have come back to us.
Sorry, I was trying to work out how you'd gone backwards, but
sorry.
Okay, now I'm with you.
All right. We did a proposal for the client. He didn't engage us. 2 years later, he comes back.
Yep.
He's closed down his business. Obviously, he couldn't deal with the avalanche of debts that came down upon the company after the ATO and Fair Work had been through. And he went directly to a liquidator, a very friendly liquidator, asked what the company has. It had $23,000 in the bank. So, according to the client, the liquidator said, right, that'll do me, that'll pay my fees, here, sign here, nothing else will happen.
Right, well, if I was a director, though, I would think that's a pretty good deal.
Oh, I think it's a terrific deal. I'd go for it. But it's never that simple, is it, Ashley? And also, again, we're not having a go at the liquidator here.
No, I'm sure he didn't say it quite like that.
I suspect the client heard and remembered what he wanted to.
Yes, yeah.
Anyway, by the time he comes to me, the liquidator has issued demands on him for about $750,000 for loan accounts, insolvent trading, etc.
So the things that we mentioned in the proposal were going to be a problem.
The things that we'd warned him about, yes. And this is where I think I did use the "I told you so." He said to me, "How can he do this to me?" I said, "Well, don't want to be the smart ass, but if had to come with us in the first place."
I can't imagine you ever saying that, Terry.
No, it went through my mind. But anyway, the liquidator was not unreasonable. He told the client that, no, be able to do a deal for about half. No, that'll be okay.
Mm-hmm.
Which is not bad. There's a saving of over 350 grand. Anyway, the client asked, "No, what can we do?" I said, "All right, we can help you. We can negotiate with the liquidator. I think we can do a better deal than 350 grand.
Right.
So he engaged us to help him out. And we got involved in negotiations with the liquidator. We put up arguments as to why his claim would fail. We convinced him that No, the director doesn't have the ability to pay him what he wants anyway. Took a few months, 2 or 3 months of back and forth. And
I think we did some pretty heavy analysis on the loan accounts and disputed a lot of those as being real loan accounts and things like that as well, didn't we?
There was that. And the loan account was pretty big, but I think it was one of those ones where when the accountant didn't know what to classify something as, it went into the loan account.
Well, and look, that's often a strategy in a normal live business. There's nothing wrong with that strategy, but when you get caught by a liquidation,
that's when it goes wrong. And I think we've addressed that before. And that's where it went wrong here. But anyway, after a few months, we did manage to settle for a little bit less than 350.
Yeah,
it was in fact a little bit less than 70,000.
Right, that's pretty good from 750.
It's not bad, not bad. The client, was pretty happy, even though he didn't engage us in the first place, and he went through a fair bit of stress in the meantime.
Yeah.
In the long run, yes, he came back and it worked out okay.
Yeah, so and if we had been able to do the whole job, like I mean, at the end of the day, those loan accounts would have still been in the balance sheet when we took it on, and the insolvent trading claims are potentially still there to be dealt with. So how would things have been a little bit different, if we'd done the earlier stuff? Now it's a loaded question because I know the answer, but
well, let's hope the answer I give you is the one you know. Well, firstly, we'd look at reconciling the loan account. So if anything shouldn't be in there, get it out, put it where it should be. That will reduce the loan accounts generally, considerably.
Yeah.
Insolvent trading, yes, we can come up with a lot of arguments for that. One is that they sought help by coming to us, whereas 2 years down the track, you have a report from us on how to deal with your insolvency. It's hard to say that
you didn't know there was a problem
insolvent for the last few years. So there's that, and also if we can convince the liquidator that really there's no point in pursuing it because the director doesn't have anything to pay, here, have 15 or 20,000, whatever. Quite often we can do a settlement just to get it done with.
Yeah. Okay. So and again, I think it's interesting, and one of the points I guess that I was pretty keen to make through talking about this story is that a lot of our clients, when they come to us, we do this every day, so we know what the process is as it goes through 2 years of a liquidation or 3 years of a bankruptcy. But most of these clients are only doing this once. So when they hear the stories out there that it's really simple, you just pay the 23 grand or leave the 23 grand in the bank and all the problems go away, that sounds a whole lot better than what we say when we actually talk about, the full impact of going through the whole thing. So again, I think it's something to be very mindful as advisors that if anyone tells, if any of your clients come to you going, oh, I found this guy, he's going to do my liquidations, he's told me it's going to be really super simple. The law just doesn't allow it to be super simple. There is stuff that needs to be done and needs to be managed all the way through. And so anyone that says it's easy is really not necessarily giving really strong advice.
That's right, Ashley. And a registered liquidator, as with a registered trustee, they have obligations. They have to do things. And as I tell all my clients and the insolvency practitioners we deal with, and the clients invariably say, oh, do you have a friendly liquidator? Well, yes, I do. I have several. They're friendly, but they have to do their job.
Yeah.
I want them to do their job. I expect them to do their job. My job is to make sure that we do stands up to the scrutiny they have to give it.
Yeah.
And quite often, the clients say, oh, I'm being offered this cheap thing on the other side. So look, you might get away with it, but you don't want to be the one that doesn't. Yeah.
And that's the thing to watch. Yeah. All right, mate. Well, let's move on from that one. We'll go back into another bankruptcy case study, the last one that we'll have a look at today. So why don't you set the scene on this one before we get into how this one was slightly different again?
Okay, Ashley, this client came to us pretty much expecting to go bankrupt. He was under a lot of pressure from a couple of creditors. He and some friends had set up a company. I suppose you'd call it a startup. It had traded for less than 12 months at that stage.
Mm.
He owned about a third of the shares. He was a director of the company. But he had debts from a previous venture that were going to, basically, they were going to bankrupt him.
Yeah.
We did a strategy for bankruptcy.
Yep.
And to deal with the company, he actually came to me with a valuation of the shares from the company's accountant.
That's pretty organised.
It's pretty good, pretty good. Saves us doing it. And the advice, among other things, was to transfer the shares at fair value, but this valuation had said there is no value. So they could be transferred at par value.
Yep.
Advised him to resign his directorship because you can't be a director while you're bankrupt anyway. So resign it beforehand and just become an employee of the company, have an employment agreement, etc.
Right.
He couldn't afford to pay us.
Mm.
So he didn't go with us.
And that's unfortunately one of the battles that we have sometimes is, people don't come to us when they're flush with money, as I often say. So trying to come up with solutions to how they can engage with us and pay us can be a bit difficult at times.
Oh, and I've often told people I really feel sorry for them because I know I can't afford to go broke. I couldn't afford to pay for it. But anyway, this client came back after about 12 months.
Mm.
Excuse me. He had been bankrupted by the court, as expected, and he was nearly 12 months into his bankruptcy when he came to us asking for help. He was having difficulty dealing with his trustee. He was under a lot of stress, a lot of pressure, and he wanted our help. The court had appointed a private trustee, and similar to the trustee who gets a file handballed from AFSA, he gets a file with nothing in it. No money, no nothing. In that case, very little information because it was by the court. Our client had not even lodged a statement of affairs, which he's required to lodge within, I think, 14 days of going bankrupt. Here he is 12 months later.
So I think that's a point that's really interesting that we've seen a few times over the journey is that technically even though they're bankrupt, their bankruptcy doesn't start until that statement of affairs is lodged.
Well, it's not that their bankruptcy doesn't start, but the period of bankruptcy standard is 3 years.
Yep.
That 3 years does not start. So if they take a year to lodge their statement of affairs, they're actually bankrupt for 4 years.
4 years, yeah. I think the record I've seen is someone who went bankrupt 10 years ago and still hadn't lodged his statement of affairs.
Oh, I've seen a few of those, and some.
Anyway, I got off track there. Please.
That's all right. Anyway, he came to us and he wanted help basically dealing with the trustee. And the first thing to do was get a statement of affairs done.
Yeah.
So we quoted him a new price. The job had changed. We didn't have control of it as we would have had he come to us, had he engaged us 12 months earlier.
Yep.
So it was probably a little bit more expensive, but not unreasonably so, I don't think.
No.
And he certainly thought it was worth paying. So the first thing we did was get his statement of affairs done. Still took a while. Our clients are sometimes a bit tardy in providing the information.
Yeah.
We got it done. We got it lodged. All's good. Let's start.
Yeah, now we can start. Yeah.
Let's see what happens. Let's see what happens next. So what happened next? The trustee sent a demand to the client's wife for the shares. He had taken our advice, transferred the shares to her at par value, $1 a share, whatever. And the trustee said, no, they were worth a lot more than that. I want to be paid what they were worth.
Yeah.
Now, a lot of people, if they don't have someone well, looking after their interests would say, oh, geez, okay, well, yeah, what do we do here? Take the shares back. We can't afford it, whatever. But the client by that stage had someone looking after him. That was us. We said, no, it's not worth that. Here's the valuation from the accountant. This is how it was valued. This is what was taken into account. And the trustee actually had a lawyer who said, no, that's not how you value shares. You can't take this and that into account. As it happens, we have a member of staff, Jelena, who is a CPA and a certified business valuer. And she looked at it and she was pretty horrified and replied, well, have a look at the accounting standards. They require this, that, and the other be taken into account.
Yeah.
And that having been done, the shares were worthless.
Yeah.
Beauty, we've defeated the trustee. Great. Great. Got rid of that. Job's done. Brilliant. Yes.
Unfortunately, my guess is there's a bit more to this story, and mate, I'm just going to put you on notice that we are starting to run out of time. So,
right, okay, I'll try and speed it up. But yes, wait, there is more, and we're not just steak knives. I mentioned briefly that the client had entered into an employment contract with his employer, the company that used to be a director of. And the trustee assessed him to pay income contributions. And when a bankruptcy is working for a related party, and it's a related party by virtue of him being former director and his wife still being a shareholder, the trustee can deem him to be earning a reasonable income, whether he is or not.
Yeah. The
trustee deemed him to be earning so much income that the contributions required were more than his gross income. Little bit difficult to meet that one.
Yeah. Yes.
We wrote back to the trustee, said, look, he was a director, but his role has changed. Here's his employment agreement. This is what his role is now. He's only working 3 days a week. He wasn't earning what you said. He was earning about 70,000. He wouldn't have to pay contributions. The trustee, and I should say, he did not explain how he came to his calculations.
Yeah.
But we asked the trustee to review, and within about 5 minutes of sending that email, the trustee rejected it. Said, no, I'm not going to review it. Go and appeal to the Inspector General in bankruptcy if you think I've done the wrong thing. He didn't even have time to read what we'd sent him, to be honest.
Yeah.
So we took his advice and we prepared an application to the Inspector General in bankruptcy to review the trustee's assessment. There's a lot of work involved in that, but we went through it and the Inspector General accepted it for investigation. And the first thing they do when they accept it for investigation is contact the trustee and say, we've had this request and we're looking into it. We're going to be asking you a few questions and getting to the bottom of it.
Yeah.
So upon putting the phone down after that call, the trustee reassessed our client to pay zero contributions. From having to pay, I think, nearly $100,000 a year, he's reassessed him down to zero.
Yeah. So they were trying it on.
They were trying it on.
Yeah.
And he had actually, the trustee had objected to our client's discharge from bankruptcy because he didn't pay that assessment within 14 days, even though he had 60 days to appeal it to the Inspector General.
Yeah, okay.
So he had to withdraw the assessment and the objection.
Right.
So, beauty, we've done a job again for the client. So you would think, wouldn't you?
You think we'd be done, but there's more.
Some people keep on coming back, keep on keeping on. The trustee next serves a demand on the company asking for a share of the profits while the client was a shareholder.
Right.
The trustee made a couple of mistakes. One is that he was claiming a share of the pre-tax profits. A little bit unreasonable there. But
yeah.
The larger mistake he made was that shareholders are not entitled to companies' profits. they are entitled to a dividend if and when the company declares it.
Yeah.
This company had not declared a dividend, and I presume they put the profits into developing the company further.
Yeah.
Startup. So we went back to the trustee and said, well, you don't have a claim. This is a try-on because no dividends were declared.
Yeah.
Again, if the client didn't have someone in his corner fighting for him, that company was looking for its own advice initially to say, well, how are we going to pay this?
Yeah.
And we've gone back and said, well, you don't have to.
Yeah.
And we've gone back to the trustee, and that was the end of that. Haven't heard anything since. Still hoping.
We're still hoping that that's the end of the battles, but
still hoping that the trustees realise that he's not going to get away with it.
Yeah, and look, we'll need to wrap up as we've sort of probably gone a little bit over, which doesn't surprise me, Terry. We know you like a bit of a chat.
Oh, thanks.
But I guess from I'll let you if you've got any sort of final thoughts or wrap ups before we actually start getting to that. And if anyone's got any questions, they can start typing them into the chat as well.
Yeah, I think the main thing to come out of this is that these people who get into financial trouble really need someone on their side, someone to go into bat for them. Now, we're not going to tell them to hide the Ferrari under the carport or anything like that. We do it all strictly legal, but we use the laws as far as we can for their benefit, as opposed to the laws that are on the other side for the creditor's benefit.
Yeah.
It's just getting fair representation, good support.
And I think, Hank and I talk all the time about that the focus of the entire firm is about holding our clients' hands through these processes.
Yeah.
And I think the other thing that I really wanted to highlight out of this is for everyone listening who we know are supporters of Jonge Read, and we appreciate that immensely. But just remember that some of these things that your clients may be hearing that go, oh, this is so much easier and so much simpler, and I don't want to pay all these fees. Just be aware of the fact that it's not the sugarcoating of it all is not. We don't sugarcoat it. We'll let your clients know where the risks are, where the dangers are. But we'll, as Terry said, we'll work with them and the whole system to actually work it for the best advantage for them.
And Ashley will probably hate me saying this. He usually does, but I'm the first. If I don't think we can add value for a client, I'll tell them that, and I won't take the job on. I'll still steer them in the right direction if I can. Tell them where to go, what to do, where to get the right representation. But if we can't add value, I'm not going to go creating a job out of it. I've got enough work to do.
And we're certainly not. I wouldn't hate you for that statement because it's one I say all the time as well, Terry. So, all right. So we will look to wrap up as we are at 10 to 12 here in Melbourne and in Sydney time, and 10 to 11 up in Queensland. And I'm not going to go around the whole of Australia with all the different clocks, but if there are any questions, please put them in the chat box. We'll open that up quickly now. Our lovely Jazz will also put up the poll just to continue getting your feedback and thoughts on how we're doing in these. We will be back next month. Can't remember the date off the top of my head, but we'll be back next month for another one. And I think we're almost getting through the full strategist team this year, which has been for me a great spotlight to give everyone an opportunity to meet the rest of the team that actually do a lot of the hard work to help our clients and to guide them through the process. So doesn't look like anyone's got any questions for us, Terrace. We've either muddled them up too much or you were just too good a speaker.
Oh, I told you it'd be all very clear and simple for them.
All right. Well,
it's been great presenting here today, and it's been great seeing my colleagues do it over the last however months and hearing all the different points of view. So I've really enjoyed it. And thank you for putting up with me.
Well, I appreciate you coming on, and I didn't have to twist your arm quite as hard as some of the others, but been a lot of fun. So we're getting a lot of thank yous on the chat. So for that, I'll say thank you to everyone. Thank you again, Terry.
Thank you all.
Everybody have a wonderful, wonderful rest of this month, and we'll see you all again next month.